If I had $1,000,000, buy you furniture for your house, maybe a nice Chesterfield or an ottoman. And if I had $1,000,000, if I had $1,000,000, well, I'd buy you a K car, a nice reliant automobile. And if I had $1,000,000, I'd buy you love. If I had $1,000,000, I'd build a tree fort in our yard.
Hey guys, this is Gary Davidson. We're just going to get started here in a couple minutes. I've got a great guy from Cook County who is one of the biggest eviction attorneys in Chicago, not by size, but by might. And Brian's going to give us an in-depth look at where we're standing with evictions and foreclosures in the Cook County court system, and really generally in the state of Illinois. So we're going to do a 10,000-foot overview on that, kind of what the process is normally, and then what the process is coming up post-COVID once we have an opening up. So let's just give it a couple more minutes, let my marketing director let everybody else in, and we'll get it going. Guys, make sure that everyone turns their video and their audio off. If there's any questions, please put that in the Zoom group chat. We want to get to all of your questions. This is a really important topic, so we want to answer all those questions for you. After today, questions are free, answers cost money. So get all your questions out right now.
We just need more. And buy really expensive ketchups with it. That's right, all the fanciest Dijon ketchup. If I had $1,000,000, well, I'd buy you a green dress, whatnot.
Okay, guys, this is Gary Davidson. This is the Castle Law Zoom podcast, where we're here to help you create that life worth living, legacy worth leaving, career worth having, and of course, investment business worth owning. We are going to be doing these once a week now. Once we get the new office, the new Castle Law headquarters open, new 10,000 square foot state-of-the-art facility, we're going to be doing these live from the studio. Right now, market's crazy, so I'm actually doing this live from the Fidelity Title in Homewood, Illinois, where we have 7 closings here today for our investor clients. So today we're going to be talking about evictions, and most importantly for investors, what we need to do to both minimize our risk and maximize our return. See, in running any business, if we can minimize our risk and maximize our return, we're going to be about 3/4 of the way there to having a successful business. And unfortunately, controlling our variables and making sure that we do things consistently and delivering a consistent product is something that we often don't do. And we start to engage in landlording out of emotion. And I'll tell you, if you're going to be a successful landlord, you have to take emotion out of it. And we have to do this as a business. So it's not based on feel and touch. It's based on, in the event that the tenant doesn't pay, there's specific steps that you have to take. Sending an email saying, I need my rent, sending a letter that doesn't have the exact statutory language is all going to get you in trouble. And it's going to get you to the point where you can never speed up the process, but we can always slow that down. So today I have Brian Krause on. Brian is from Hoffman Estates. I've known Brian a long time. Brian and I are working on a affiliation in some sort, shape or fashion or form with Castle Law. We hope that potentially we may have a Castle Law North, but we'll be letting people know that in the very near future. So Brian, thanks for coming on. I know your focus has been on evictions for the last umpteen years. So first, before we get in the normal eviction process, what is going on right now in the Cook County courts, and can we do evictions or can't we?
Gary, first of all, thanks for having me on. I'm happy to discuss these issues. With regard to your question about what's going on now, generally speaking, we're in an eviction moratorium. And what that means is you cannot file any residential eviction that's based on non-payment of rent or other violations that aren't considered emergencies. So for instance, if you've got, I get people calling me, some of them will say, look, my tenant hasn't been paying since before COVID. I say, regardless, unfortunately, you still can't file those evictions. You can get the process started. You can serve them with a notice, a non-payment notice. If there's some other violation, they've got pets in the unit that's in violation of the lease. You can get them a notice for that. You cannot file those evictions. Now, I mentioned that there are exceptions. There are exceptions for health and safety issues. Here's the problem with that, though. And I'm not going to get too political or anything like that, but in my opinion, this is why I think executive orders that are unilaterally delivered by the governor are such a bad idea, because so many of these issues that need to be fleshed out by a legislature just aren't fleshed out. The moratorium, the moratorium orders say that there's an exception for health and safety issues, but it doesn't really elaborate on what those are. So what I've been telling all my clients, if there's even a question that they might be able to get someone out on a health and safety issue, I tell them there's no guarantee that a court's going to see it the same way. Now, practically speaking, even if you've got something that's clearly a health and safety issue, and I'll give you an example. If you've got a tenant who's going around threatening people, making excessive noise, has some kind of biohazard or something on the premises, you file that case, you're still practically speaking running into all the delays that are happening because of COVID. And I'll give you an example of what I'm talking about. I have filed a few, and this is kind of what's a little bit unfortunate about this. I was kind of hoping I'd have an answer on some of these things as to what does and doesn't constitute a valid emergency, because I was hoping to have experience with a few of these cases. I filed them. They've all gotten delayed because what the judges are doing is they're just taking these residential evictions, and actually some of my commercial evictions are not supposed to do this, but they're taking them and they're just pushing them past the moratorium date. So for instance, in DuPage, I had filed a few emergency exception eviction cases. They were set for various dates in August. I got a letter from the court saying the judge just unilaterally, by administrative order, without me being in court, without me even knowing it, pushed the cases back into September.
So wait a second, let me just,
Sure.
This was in DuPage County. So guys, just think about this. DuPage County is known to be more friendly.
Correct.
To landlords.
Correct.
And even in DuPage County, these cases are getting continued out, let alone what might happen in Cook County, which even prior to COVID was somewhat hostile to landlords.
If you'd like, Gary, let me elaborate a little bit on what I've found in Cook County as well. Mm-hmm. So with Cook County, with Cook County, I've at least been in front of the judge. The DuPage judge who does all the evictions, I haven't seen him since February or March. In Cook County, at least in Rolling Meadows, and actually one case at the Daly Center, I've at least been in front of the judge. But what that judge has told me is he said, what those two judges have told me, they said, look, by administrative order of the chief judge, we're pushing all these cases back. So practically speaking, even if they're technically an exception to the moratorium, you're probably not getting them in front of a judge. On top of that, here's the thing too. we haven't really had good guidance. It's kind of a free for all, kind of a limbo going on there right now. Technically, the sheriff is supposed to be serving summonses for these evictions that are exceptions. Sadly, because they changed their system, you actually physically have to go to one of the sheriff hubs to take your complaint, your summons. So I figured, it was about a month ago, I said, you know what, I ought to really go in. I've got one of these. It's an emergency exception. I knew it was going to be a big delay because of COVID, but I thought I need to go down and get this in front of the sheriff, get it served, whatever. I got there, and one of the few people at the Cook County Sheriff's Office that have ever really been helpful to me, there's this lady there. I've known her for years because I've been doing it plus years or whatever. And I said, look, what's going on here? You know, is the sheriff actually, executing any of these evictions? What's going on with these summonses? She said, to be honest with you, she goes, even though these are exceptions, she goes, I haven't seen any of them served. She goes, they go into a box. She goes, they go into a box. And I said, does that happen at all the other, like the 6th district, the 5th district? She said, as far as I know, she goes, I can't get anybody on the phone at those hubs. And she goes, I don't know if anybody's even working. So what she advised me to do is she said, anytime you've got one that's an emergency exception, what you should do is you should file a motion. Just get a private process server. Try to get in front of the judge because the sheriff's not doing anything. As far as I know, they're still not executing the orders that are for these exceptions.
Okay, so let me just summarize here. We have an eviction moratorium as general overall. No evictions can proceed in the courts in all counties in the state of Illinois based on an executive order of the governor. Their governor has placed a carve-out exception for things for health and safety issues that would allow for an emergency eviction proceeding. However, the court system is simply not really recognizing that as an emergent situation. And despite filing that, it's still getting pushed off. And we kind of have handcuffs associated with that. So let me take a step back because we've got a lot of people that are going to be listening that probably have never even performed an eviction. So let's just give a 5-minute overview of non-payment of rent, what's step 1, step 2, step 3, and what are the associated timelines for those steps in a normal world.
I'd be happy to go into that. Before I do, I just want to correct one small thing because I think the summary you just gave was mostly correct. I would say, and I'm just saying this because I don't want to be deceptive, I do think for certain emergency exceptions, if you're aggressive in filing motions, I do think you can get it in front of the judge, and I do think that they will issue the order. I don't think the sheriff, based on what I've been told, the sheriff's going to execute it. But I wanted to clarify that the big point there is it's even when you have this exception, it's being slowed down administratively. So if you're really aggressive with filing motions and getting in front of the judge, I believe you can. It's going to take a long time. And I know everything of mine is just taking a long time. And I know my wonderful clients, I know they're frustrated. And my phone's ringing off the hook. Some of these people are shocked that they can't file an eviction. It's been 5, 6, 7 months since they've been paid rent. So that's that. But to answer your question about how things proceed normally, and I'm going to do that, and I'm going to explain how things proceed normally outside of Cook County, in Cook County, and then specifically in the city of Chicago, if that's okay, because they're all 3 of them are different.
Yep.
All 3 of those situations are subject to the state law. In Cook County, you've got the extra inefficiencies of the Cook County Sheriff. And then in the city of Chicago, you've got the Chicago RLTO, which is, even aside from COVID and even aside from the new amendments they made, is horrific. It's just horrific.
It's the landlord-tenant ordinance that you're referring
to. The residential landlord-tenant ordinance. So let me start with just your normal simple eviction that you would get in the collar counties, okay? Obviously, the first step is to serve some kind of notice, whether that's a 5-day, a 10-day, 5 days are for non-payment of rent, 10 days are typically for violations that you have in the lease. The lease says no pets. Tenant brings in a pet. You want to get rid of them. You serve them a 10-day. And then you've got, if you're like month to month, you give them a 30-day non-renewal, starts the first day of the following month, runs 30 days. Okay. So
and you have these, I'm just going to keep jumping in here.
Sure.
You've got all of these different notices, and depending upon what the lease says, that could also change things, because if the lease gives more time, you have to serve what's set forth in the lease. And those notices have to be served a specific way.
That is correct.
And they have to have specific language, and failure to have the exact language, the exact statutory language that you have in your forms, in those forms, or served in the exact way as set forth by statute, which you have process servers that work for you. Short of that, you could go to court, and that case will be 100% thrown out because it didn't follow those statutory procedures, because it's a strict interpretation. It either has those words and was served that way, or it's no good. You start completely over, right?
Gary, that is correct. And I can go, as much as you'd like, I could go into the specifics of the notices. You make a good point. The biggest thing in these cases, the easiest way to get one of these thrown out or to lose one of these cases is if something is awry with your notice. And you mentioned it's got to be served a certain way. For the most part, and there are exceptions and whatnot for various situations, for the most part, what I always recommend people do is that they get that notice in the hands of somebody who's 13 or older living on the premises. You can send it certified mail. The problem is if they don't sign that green card, it's no good. So I'm glad you brought up service of the notice is huge. The language in the notice is huge. If you serve a 5-day, which is the minimum amount of time you have to give per statute for a non-payment, but your lease says that they get a 10-day, you better give them a 10-day or that's going to get tossed. So that was another good point you brought up. What I would say too, and a lot of people don't know this, as strict as the statute is about how people are served, you can draft your leases in such a way as to where you got to have this language very clear. And I would recommend that people have the tenant initial this section of the lease, but they can waive their right to be served in person or by certified mail. For instance, you could have them agree to be served by mail, agree to be served by posting. This is something that throws people off.
Well, hold on. I'm gonna jump in here because
Sure.
You and I talk in legalese, and sometimes these guys don't necessarily understand legalese. So,
Sure.
Literally, what we all commonly know as the methodologies by which we serve 5-day notices, have it served above the age of 13. It's a person handing it to someone, not slipping it under the door, et cetera, et cetera.
Correct.
Castle Law and Brian Krause have the language in the forms and the stuff to put in your leases or the leases that people can use so that we can help make things more efficient and minimize the risk and maximize the return is what I'm hearing.
Correct.
Awesome.
Correct. So what a lot of people do, what I find a lot of people do is they will tape it to the door. Or see, here's the thing too. You can find a lot of these standard forms on the internet, and people will see these affidavits and they'll see that one of the boxes says that you could post it on the door. It's confusing. In most situations, unless the tenant has signed off in the lease, you cannot post it on the door. The only time you can post it on the door is if they're gone for an extended period of time, but they've left their property in the residence for whatever reason. It's the one time you can get away with posting. But the key here is the biggest thing in this is proper service of the notice and proper notices. And if you don't do that properly, you're going to run into a problem in the court.
Can they serve this now? I mean, with COVID, that 5-day notice, is the eviction moratorium have applied to the service of a 5-day notice?
No, you are allowed to serve your notices.
What would be the benefit of serving that notice now versus waiting for the eviction moratorium to lift?
Well, you serve it the same way. There's no change in how you're supposed to serve it. You would think with all the other goofy COVID regulations that they would have altered that, but they haven't. You still serve it the same way. Here's something I find a lot too. Another way to get these things thrown out. I understand that by the time this gets to an attorney, the tenants or the landlords are very nervous. They're very understandably anxious to get these people out of their property. I do find that people are a little trigger happy though, because they want you to get that case on file. What I always tell people is whether it's a 5-day, 10-day, 30-day, give it a few days after delivery. You never want, there's some complicated stuff written into the case law and the statutes that say if you're premature in filing after you deliver that notice, you can get your case dismissed. So I always tell my clients, look, I feel you. I know you're losing money. I know you want these bums out. I get it. I'm with you. But it doesn't make sense. The only times I've ever had a problem really lose it, and I almost never lose on these cases because they're not really that hard to do. The only times I've ever lost is when there's been some kind of foolishness with the notice. And I'll get landlords who say, oh yeah, I served it. They'll get to court, they'll get under oath, and it turns out they didn't. They posted it on the door. Or they wanted me to get it on file. I got it on file, and it was like, oh my gosh, it was, we didn't wait the long enough time before filing. So the notice is huge.
So what happens after the notice?
So after the notice, let's assume the time frame has run. They haven't paid, they haven't left, they haven't, done whatever. At that point, we're ready to file. So we file the case. I can do that online. I just, the new rule, of course, is if you've got a lease, you got to attach the lease. You want to attach the notice, the affidavit of service, you file it. You get a court date about 2.5 to 3 weeks out. From there, in the collar counties, you can go right to a private process server, which I always recommend. It's better than dealing with the sheriff. Go to your private process server. Hopefully, they get that served on before the first court date. If not, you got to ask leave to do an alias summons. If you still can't get them served, then the court will allow you to do a posting, provided you've got an affidavit that says you made your best effort to get them served and they're just not being responsive. Pardon me. So if you get them served though, at your first court date, going to be about 2.5 to 3 weeks out. What happens after that really depends. They could come to court guns a-blazing, wanting a fight, and the judge is going to set it for a trial. One point about that, because I get a lot of questions from my clients, because I'll come back from court and typically the client doesn't come on the first date, nor should they. It really makes no sense. But I'll come back from court and I'll say, well, these folks had a head full of steam and they want to fight, so we're going to trial. And a lot of times my clients will be like, well, why are we going to trial? They owe me the money. They have an absolute right to go to trial. If they ask the judge for a trial, they get a trial. A lot of times it's just to waste time. It doesn't matter. It doesn't matter whether they owe you. It doesn't matter whether you did everything right, et cetera, et cetera. If they want a trial, they're going to get a trial. The judge will give them a trial. So there's no way around that. They could come in being cooperative and offer a settlement. That's one thing they could do. They could, if they've been served, they could not show up. And sometimes the judge will give you a default judgment right there. Sometimes he or she will make you come back and do a prove up. Why they do this, it just depends. Sometimes they've got a busy court call and they just want you to come back. Other times they just want to give the tenant maybe another chance to file a motion to vacate or something along those lines. Sometimes they're cool and they'll give you a judgment right there. Just depends. So now, once you get your judgment.
Okay, so I'm going to, again,
sure.
Guys, and I want to speed through this a little bit because I want to get to the COVID stuff. But so we've got, we can get our notices served now, even during COVID. 5-day, 10-day, 7-day. You're going to need to call Brian, find out what notices, the type of notice. We want to use a private processor server to serve those notices every chance we get, because if you use a government employee is getting paid no matter what.
That's outside of Cook County though. Just keep that.
Right. A private process server is going to get, Cook County, but for 5-day notice, we can use private process server.
Oh, yes.
Right. So for the notice, we can use private process server all the time. It's only when you get to court, and you file your complaint, that in Cook County, you have to start first time by using the Cook County Sheriff. So
Right,
that
and
5-day notice is going to take somewhere between, from the time you call Brian, that's going to take somewhere between 7 and 14 days to get it served, because they got to go out and serve the person, right?
correct.
That's 2 weeks. Then once that time period runs, we have to file the complaint. That's another 2 or 3 weeks. Then you go to court, depending on what the judge says. If you have to come back, that's another 2 or 3 weeks. And then Brian's going to tell you the process about what happens when you get your judgment. But just know now, this time frame that I've just given you, even pre-COVID, we're talking about 6 to 12 weeks plus before you have possession. We'd probably do another episode on how to collect your money. Generally speaking, landlording is about basically cutting your losses, not recovering your losses, right?
Correct.
So this is why we have to do this very, very quickly. It's just like owning a grocery store. A certain amount of lettuce is going to be spoiled that doesn't get bought. With landlording, we have to get that property back and relet. If the person isn't paying you, they're probably, after they get a judgment, not going to voluntarily pay you. They may have their cash under a mattress. It's very, very difficult to collect that money. And sometimes
Correct.
it doesn't make sense from a financial perspective.
Correct.
So at the point that it goes to the point where you have your judgment, whether it's after your trial, whether it's through a default, then that process with the sheriff, what does that look like?
Very good question. So, and this is where the differences between Cook County and the collar counties come into play. The way, so you get your judgment, right? And typically, for a standard non-payment, the judge is going to give a stay of two to 3 weeks, all right? Usually minimum of 2 weeks unless it's a default. So 2 weeks go by, they haven't left. You got to take your order, you got to take it down to the sheriff, whether that's Cook County, DuPage, whatever. You give that order to the sheriff, they take it, put it at the bottom of their pile, right? Now, in Will County, in DuPage County, Kane, whatever, the collar counties, you're looking about 10 to 21 days before they throw the guy or gal out, okay? Cook County, you take it to the sheriff in Cook County, it's anybody's guess when they're going to do it. They, in the 10 plus years I've been doing this, sometimes they'll have me wait a couple weeks, very rare because that's quick. Usually it's at least a couple months. It's taken them as much as half a year at some points to get the people out. So when somebody asks me, like, could you please just give me an estimate of how long the Cook County Sheriff's going to take? I say, no, because I don't know. Anything I tell you is not truthful, because I really don't know. They have so many different experiences with the sheriff. And a lot of it depends on how many they have. And it also depends on where they're going to be at. Sometimes they can take an eviction order that you just give them. If one of them got canceled or something, they happen to be going in your area, they'll do yours too. So on a few occasions, they've blindsided me with doing them too quickly because, especially with the commercial guys, they've got to assemble a crew, and I'm like, what I'd been telling them is probably going to take a couple months, and I get a call, like a week or two later. So the way they do it is, I don't know if you want to go into this, Gary, but the way the sheriff in Cook County does these evictions is horrible. But that we could, if you want me to get in that, I can, or we can.
Yeah, no, because what I want to do is I want to move out. I want to move to COVID, and I want to move to what people should be doing to put themselves in the best position to get their properties back, to get to the front of the line, some techniques that they could be using, alternative strategies. Obviously, everybody, for the forms, for the eviction notices, you don't have to worry about, taking notes on, you have to place it, with the sheriff, and you have to, use the Cook County Sheriff first, but in DuPage County, you don't have to. We take care of all of that for you for a flat fee. You don't have to worry about any of that stuff. The key to this exercise is most investors, for whatever reason, run their business based on emotion. If you're going to run your business based on emotion, you are going to lose. you have to have a specific process, just like McDonald's. When the order gets taken, this happens, this happens, this happens, the fries come out crispy. Same thing with landlording. You don't use feel and touch. If they haven't paid on the 1st, you have to have a system in place where the notice goes out on the 4th. No exceptions. Tenants are like our children. If you give them an inch, they take a mile. Blame it on your company. Most of you have companies, so it's not personal. You say, I'd love to help you, but my company policy is X, Y, and Z. So with respect to COVID now, nobody can file evictions with the exception of the emergency exceptions. We had a question about what constitutes an emergency exception, and I think Brian discussed, the governor hasn't outlined what an emergency situation exists. I think Brian also eloquently described that, if the emergency situation is that the tenant's being noisy, that they didn't take their garbage out on time, those sorts of things in general, this is not, the golden rule, but in general, judges aren't going to be very understanding of those things. If somebody just went out and is, shooting people in the street, running a crack house, doing things that are, truly health and safety issues, by being aggressive, by filing motions and spending the money, we're going to be able to eventually get that into court, although it's going to be still frustrating and cumbersome. We're going to be able to get somebody's attention and say, Judge, if we don't handle this, someone else is going to get hurt, okay? But Brian, with respect to COVID, courts have been closed since when?
Well, the moratorium started April 23rd, but before that, the courts. I don't think I got back into court till June.
Okay, so think about this, guys. We live in the state of Illinois. The state of Illinois has more governmental entities than any other state in the United States. Cook County is not known for its efficiency. Things were very, very slow before this. So now we're at March, April, May, June, July, August. 6 months. So things were backed up before.
Yep.
But it's not a day for day backup, because once you start backing up, if anybody, you start getting busy with whatever you do for work, right? You can handle 4 things, 5 things, but in 10 things you might be able to, handle, but it's a little efficient. When you get 20 things, you become even that more exponentially inefficient. So we don't know what's going to happen, but we know that even getting to court, even getting that first date, because what are they doing, Brian? Are they going to take these they're going to do all the old cases and they're going to kind of just take them in the order in which they're done, right?
Absolutely. Again, just to give you an example, I've got pre-COVID cases in DuPage County that have been continued by admin order to October 7th. So when I start filing the new ones, I can't even begin to tell you what my first date's going to be.
So we have to, the lesson to be learned here is we need to get all of our 5-day notices served. We need to get our leases in order. We need to take this time to actually get our house in order such that when Brian can file these, that our clients are the first ones through the door, because Brian's going to be waiting there so that you're not standing way back in line, so that we can get these properties back at least to tenants. So, I've heard that due to COVID, it could take 12, 18, 24 months for these cases to be over. Are you hearing anything? Is it all just speculation?
It's all speculation, but what you just said does not sound outrageous to me, especially for Cook County. I tend to think that once we can file, the collars will be a little faster, but I can't even imagine what's going to happen in Cook County. And you couple that with Tom Dart's terrible attitude of, I want this a moratorium to get pushed further. I couldn't even begin to tell you how long it's going to take. 18 months, 24 months does not sound outrageous to me. I don't want to commit to that because I'm hoping and praying it's going to be a whole hell of a lot quicker, but we got to see. Some of this is we just have to see.
And there's things that we're doing right now for your clients where we're putting things in place such that we're at the front of the line so that we're going to be at the short end of that time frame rather than at the long end. So here's the real $1 million question. I know we opened the meeting with, if I had $1 million. Well, here's the $1 million question. What can people be doing right now? What's the one thing such that if someone did it, everything else would be easier or unnecessary? What are the things that people should be doing right now with their tenants? Cash for keys. What are some of the strategies?
Very good question. Here's one thing you have to do. And I've said this to people, and I've said this, and keep in mind when I say this, it goes against my interests because obviously I make money when I file these. But what I've said, people kind of have to make a decision. If they're in a situation where a tenant is not paying in full, but they're paying, I think a landlord has to sit down and think, okay, here are the possibilities of how long this is going to take. Do I try to work with this person? Because the more you work with them, the more you work with a tenant, the longer that delays things. Because obviously you serve a 5-day and then you keep accepting rent thereafter, even if it's, less rent, and that goes on for a few months, you've kind of knocked out that notice then. You almost have to start the whole process over again. But what I've told people is because this is such a bad situation, a couple of my clients, I gave them notices. They delivered the notices. Tenants paid but didn't pay in full. They said, what should I do? I said, look, it's going to be months. So do you want to be months without that income? In that case, they traded the desire to get some income for the speed with which they'll be able to get the people out. In other situations, your whole thinking is different because maybe the people they're bad people. They're beating the hell out of your place. You want to prioritize then getting them out as quickly as possible. If that's the case, you don't want to accept rent, and you might want to consider, you brought up cash for keys. If you have a tenant who's willing to take cash for keys, and your goal is to really get them out, I recommend you bite the bullet and pay the money, because in the long run, if they're willing to leave for, $2,000-3,000, you're going to save yourself a whole bunch of money. You're going to save on attorney's fees, months of lost rent. If you're confident you can get another renter in there, right? I mean, I suppose a lot depends on your particular situation. But if you can do cash for keys, now I wouldn't give them any cash till I have the keys. You don't want to give them money and then they not leave and you're in the same boat anyway. You're just, out all that money.
So let's talk about that for a second, Brian. So, what you're describing, and people may be familiar with this concept, is analyzing what our BATNA is. BATNA stands for Best Alternative to a Negotiated Agreement. We've kind of described and given you the time frame on what your best alternative to a negotiated agreement is. So while we may not like that, we used to use that as our backdrop by which we make decisions. Now, relative to the cash for keys, you talked about don't give them the money until they move out, et cetera, et cetera. I mean, I think we've got cash for keys agreements that people will sign, that you show up and the cash for keys is conditioned upon them delivering the property in broom clean condition, free of any defects, because we want to ensure that that property is given back to us in a relatively good condition. So someone would meet them at the property after they get this cash for keys agreement from you. They would, after that cash for keys agreement is signed, let's say they sign it on August 1st, they say they're going to meet them on August 30th. Then on August 30th, you meet them at the property with the envelope full of money, and one person gives the keys and you give them the envelope of money. And then that cash for keys agreement is going to say things like, again, we want to minimize our risk. We want to maximize our return. So it's going to, I'm assuming, say things like that they confess that they're in breach and that they're getting this agreement in exchange for tendering possession, and that they are releasing us from any further liability in violation of the lease and violation of the landlord-tenant ordinance, and all the lawyer stuff that we put in there, right?
Correct. And I want to make a really important point about that, though. The agreement is important because it does protect you from accusations of an illegal lockout. But that agreement, though, that they sign is still of limited value. And the reason why I want to point that out is because if they're not physically getting out of there and handing you the keys, but they sign that agreement, think about it. You've already got a written agreement. You've got a lease. So if all they do is sign that and you hand them before they're physically out, you hand them the cash just in exchange for the agreement, you're still in the same boat. If they don't get out, you still got to take them to court. That agreement is about as good as your lease, which you're still going to take the same amount of time. But I do agree with you, Gary, that you should get that agreement signed anyway, because after they're gone, if they try to say, oh, I was thrown out, whatnot, well, you've got the agreement that says, no, this was all done above board. But the agreement itself, you can't rely on it. It's the agreement plus the handing of the keys plus all their junk is out of there. I mean, if they sign it, give you the keys, and they still got junk in there, I wouldn't hand them the cash. I'd say your stuff's got to be out, because then we're going to be in the same boat we were in. So
okay, so now question, and guys, we got about, I'll give this about 10 more minutes. I want to wrap this up. I try to get these done in 40 minutes, but this is such a in-depth topic and so timely that we're gonna use an extra 10 minutes here. So if you have questions, please put them on the Zoom group chat on the side, and Brian and I are going to cover those in the next 8 minutes. If you need to contact Brian or I, you can contact myself at gdavidson@castlelaw.com, gdavidson@castlelaw.com. I'm glad to connect you with Brian. One of the questions we have from Marta is, if you buy an auction property occupied by a former owner, so this is an auction.com property, REO property. REO stands for bank-owned property. Auction.com, for those people that don't know, it's a site that REO properties are sold on. Typically, auction.com properties are owner-occupied properties still. They're selling them subject to the rights of possession of a person in possession, which is why you're getting it at a low cost. Is the eviction procedure timeline the same? Does the eviction moratorium also apply to them? Yes. Brian, you agree?
yes, the moratorium does apply to them. The timeline is a little bit different, and it depends. Excuse me. It depends on if it's a bona fide tenant or not. If it is a bona fide tenant, it's a lot longer. You got to give them a 90-day notice. If it's not a bona fide tenant, it's actually quicker, because all you have to do is give a demand for possession. If they're just a trespassing squatter who's established residency, you just give them a demand for possession. You still got to go to court, which sucks. But the time frame is either better or worse depending on whether or not it's a bona fide tenant. Do you want me to say what a bona fide tenant is, or does that?
Yeah, absolutely.
A bona fide tenant, per the law, is somebody who signs a lease with the old owner prior to the filing of the lis pendens and the foreclosure. It's got to be at arm's length. It can't be a family member, or there's some exceptions, but it's not supposed to be a family member, and it's got to be for market rent. So you can't have this situation where the owner knows he's getting foreclosed on and he lets his brother live there for $100 a month. That ain't going to work. But if you got a genuinely, before the lis pendens, bona fide tenant signs a lease, pays market rent, it's arm's length, you got to give them a 90-day notice before you file.
So guys, there is so many different pitfalls and landmines when it comes to these evictions that it's very, very, very simple, yet very, very, very complex at the same time. Because any one of those things that you don't do exactly right can put you in a position where you're literally spending additional months to get the tenant out, and most importantly, subjecting you to liability. liability under the Chicago Landlord Tenant Ordinance and liability in other ways. So it's extremely important that you do this. All right, we're getting a bunch of questions here, Brian. You talked about this lease provision that you'll give to clients to add. Can a clause be added in the lease saying that I'm assuming she's referring to the 5-day notice for non-payment of rent. Can that be served all the time by posting on the front door if that is provided for in the lease agreement?
Yes.
Okay. And have you had any situations, because I'm actually learning something here. I didn't realize this. Is that, I guess when we get into the eviction courtroom, because we're not talking about hundreds of millions of dollars, ultimately it's probably yes with the asterisk that these judges literally could probably do whatever they want, and we really don't have much recourse because we're not going to go to the appellate court and spend $100,000. So
Very good point.
we had situations where that was used and judges ignored it.
Very good point. I've been successful every time I've used it, but given that a lot of these judges, believe it or not, don't really know the law, sometimes you have to educate them on the law by showing them where that's allowed. Some of them, you made a good point, Gary. If they don't like it, if there's a judge who doesn't like it and says, you know what, I don't find this equitable, I'm not going to enforce it, that judge knows you're not going to appeal on a stupid eviction case. So guess what? You're stuck. But I think it's worth it. It's worth it to take him if he dismisses the case. What I always do is I'm always willing to refile it. I mean, obviously the client has to repay the filing fee, but you just serve them again. Some risks are not worth it. Some risks are worth it. And I think if you're having a hard time with a tenant to be served and you do that in your lease, I think it's worth taking a chance.
Okay, so great point that you made, and I want to talk about this to people because I don't want people to take shortcuts. And what Brian said is, even if you have that lease provision, it doesn't mean that you can't serve it the statutory way.
Correct.
And what I will tell people is this. Again, tenants are much like our children. I do not like when a landlord serves their own 5-day notice, because it's the difference between me telling my child that they need to clean up their room and another adult telling them they need to clean up their room. There's a far greater chance that if you're using a third-party process server with a revolver strapped to his side, that they're going to take that in a much more serious fashion than you saying, I really mean it this time. So serving that 5-day notice with a private process server, handing it to the person, is always going to be the best method to give you the greatest opportunity to have the money paid. Now, I love Brian's idea of having that in your lease as your fallback, right? As your fallback if you have trouble serving that 5-day notice, so that we can keep that process moving. I just don't want you to get lazy and start using that every single time. Brian, am I kind of spot on that?
I think so. I think you're right. I mean, the best way is always to get it in someone's hands regardless, because there's never going to be a question then. So I agree with you.
Okay. Just a couple more things and then we're going to wrap up, guys. What if, and I'm reading this without pre-reading it, so if this is what if someone broke into the empty property, essentially, this is kind of an interesting question. A squatter. What do we do with squatters? Someone breaks into a property and starts living there. Happens all the time in Chicago. Do we still have to go to court?
You do, unless you get them really, really quick. So if pretend this is my house, they break in downstairs, I call the police, they get arrested. Or I'm driving by and I see them as they're breaking in. If they're there for any reasonable length of time, they get mail, the police don't want to mess with it. They're going to tell you to go to court because they're going to say, well, they established residency. It's nuts. I know it's nuts, but it's just the way it is.
And John Pizzullo actually has another good question. I think it's, he's got an auction.com property. He's got an eviction notice that was served before January 4. I'm assuming, John, when you say eviction notice, you're referring to a judgment of possession. Okay. That's a court order where the judge says, landlord, you are entitled to a possession. So if your question is, if the seller already has a judgment of possession from January before COVID, can they use that judgment of possession with the sheriff, or do they have to start all over?
Very good question. So the normal rule is after 120 days, you have to get it renewed. So if you have an order of possession, you file a motion, you get it renewed. I do believe, and I'll have to double check because it's been a while now and they keep changing this, but when they first started pushing these back, the chief judge said that as part of that, there was an automatic extension on old orders of possession. So what I think is that your order is still good. If for some reason it's not, all you need to do is file a motion and the judge will extend the time for the enforcement of it for another 120 days.
Okay. Deanne wants to know, can landlords serve 5-day notice due to non-payment of rent as opposed to a process server in Cook County? Guys, every single 5-day notice, doesn't matter if you're in Chicago, Cook County, Winnebago County, all 5-day notices can be served by you or a private process server. The only time that a Cook County sheriff, or the only time a sheriff has to make an attempt is by statute. The statute says first attempt has to be made by the Cook County Sheriff's Department. Why is that, guys? Why is that? Money.
Yeah. It's
Money.
a legal racket. It's a legal racket. The statute specifically makes it so the Cook County Sheriff gets your money.
Yep. And if landlords that pay for water and gas, can they disconnect if they're paying for their water and gas?
Yeah, I run into this question a lot, and please don't, I'm on your side. Don't misunderstand. I'm on the landlord side. I think landlords who go down this route are asking for trouble. First of all, no, you can't unilaterally, let me explain it this way. If you stop, you can, if you're paying for the water and gas and the bill's coming to you, technically you can stop paying it and say, I just don't have the money. I don't recommend you do it because that's your property. That is your investment. You don't want, in the winter, you sure as hell don't want the heat off. You don't want the water to stop running because that's a sanitation issue and they're going to beat they're going to beat your place up pretty bad. What you definitely cannot do is proactively have it shut off. So if you call in and say, I want my tenant's water shut off, big no, don't do that. I would recommend to people who say, well, can I just stop paying it though? Just say, well, I'm not getting rent, I can't afford it. I recommend to people, I don't care if it's 5 months, a year, whatever. I don't care if you feel like you're being ripped off. That property is your investment. Unless you're willing to let it, rot, I'd make sure I would pay the water, the utilities, no matter what. And I, whether they're getting away with something or not, I don't care. It's your investment. You don't want your investment ruined by not having utilities running through the property. That's my opinion. Legally, you can stop paying. You can't proactively have utilities shut off, though, if that makes sense. Does that answer the question, you think, Gary? Yeah,
Absolutely. Thanks, Brian. So, guys, if you have any further questions on landlord-tenant, you need the forms, you need leases, we're here to help you and give you a hand up. We want to make sure that you're successful. That is my why. That's my foundational belief when I wake up in the morning. That's what lights me up and pays me well at the same time, is seeing people succeed, helping you avoid those pitfalls, helping you avoid those landmines when it comes to landlording. Again, when it comes to landlording, we're trying to minimize our risk, maximize our return. We're going to control our losses and make sure that we have cash flowing properties. Brian, thanks so much. If people need to reach out to me, please, G. Davidson at Castle Law. If you need to get connected with Brian, reach out to me. I'll connect you with Brian. This is the Gary Davidson Castle Law Zoom Crossfire, where we're here to help you create that life worth living, legacy worth leaving, and business worth owning. I'll stick around just for another minute or two if anybody has any other questions, but make it a great day.
Thank you, Gary.
If anybody has any other topics that they want us to talk about, it's not very often that you get two lawyers that are going to be billing $450 an hour, spending an hour with you, answering your questions for free. That is something I like to do. I like to give back. So if you have any other topics that you'd want to be discussed, feel free to send me an email to gdavidson@castlelaw.com or just throw it in the group chat. Don't forget, subscribe to the Castle Law Zoom Crossfire channel. My marketing director, Michael, has that in the group chat. Just click the link and you can subscribe. If you want to send me an email, we'll put you on our email list where we notify you of the webcast and all the things we're doing here. So without any further questions, we will sign off. Make it an awesome day. Make it a great weekend. And everybody have a great Labor Day next weekend. Open the fridge and stuff. There are already food laid out for us with little pre-wrapped sausages.